or working,
And also,
as a counterpart.
yeah, and Colleen always loved Isabella so much. And Colleen's actually the way that I didn't get to know Isabella while making the movie because we met a couple times, but we weren't working together.
Yeah.
And Colleen is really the one who, Colleen connected with me initially, and then she connected, and she had been connected with you and connected you and me. And Colleen really has been not only the heart and soul of the source material, but the heart and soul of the relationships in the most beautiful way.
Hi friends, it's Katie from Without a Crystal Ball. Welcome back to my channel. What if I told you that Justin Baldoni's answer to Blake Lively's lawsuit gave me a light bulb moment when he made a response to a document that she has been hanging over the heads of everyone and using as a weapon, both as a weapon professionally to get access to more control on the film, but also socially by using this to persuade people in the public into believing that a document that she quote unquote signed and that was 17 points to return to work benefited everyone and kept everyone safe on set, and that she negotiated for the behalf of everyone. What if I told you that was a freaking lie? Justin Baldoni entered into an agreement not with Blake Lively, but with Blake Lively's entertainment company, Blakel Inc. Blake Lively is the only officer of this company. Blake Lively's company, Blakel Inc., had been relatively defunct for years, and she reinstated it in the summer of 2023. While she reinstated it, she listed herself as the only officer. The company is for entertainment, and her company was agreeing to lend her out to It Ends With Us. Her contract agreement was not with Wayfair Studios. She was not an employee of Wayfair Studios. She was a contractor for It Ends With Us, the movie LLC. She was contracted to work on a film as an artist. She was not an employee. But in his answer, this is where I woke up. Answering to the allegation 16, he says the defendant admits that It Ends With Us movie LLC and Blakel Inc. entered into a document entitled Protections for Return to Production, attached as Exhibit A in the complaint. He denies that Lively made any formal complaints, and Wayfair failed to investigate or address any such complaints. That the protections for return to production were designed to require Wayfair to cease any on-set behavior of Baldoni and Heath or remedy any alleged misconduct. He denies all remaining allegations. So Blake Lively signed a contract where she didn't sign the contract as herself. She's using a loan out company. The loan out companies basically serve as Blake being a complete independent contractor. Wayfair and It Ends With Us does not pay her directly, it pays her company. And a lot of actors use these because it enables them to take tax deductions and income tax deductions for their management and attorney's fees that they have to pay for their agents directly from their income taxes. But the California government just recently passed stricter laws regarding this. Not considered an employee of the production company, and thus she's not an employee of Wayfair's, nor is she an employee of It Ends With Us, LLC. It has tax advantages for her, but her employment relationship is with the loan out company and not the production company. The actor cannot sue the company as an employee. They can still have legal recourse with the loan out company or the production company if there are issues with the contract or other aspects of the project. But she cannot sue as an employee, meaning she cannot sue under California labor laws because Wayfair and It Ends With Us LLC were not her employer. I'm not sure if they will argue this or not, but under the law in California, some of the claims that she's making are actually not protected under the way that she's contracted. For instance, because she is listed as a contractor through the Blakel Inc., she does not receive Title VII of the Civil Rights Act of 1964. So she's not allowed to bring charges under Title VII of the Civil Rights of 1964. She can only bring claims under the Employment and Housing Act, FEHA, which is more narrow than the Civil Rights Act of 1964. This might be something that Brian Friedman and his group look into, but because she was not listed as an employee for them and her contract was with Blakel Inc., she did not fill out the CRD complaint correctly, and she would need to have filed this under Blakel Inc. So she could have sued under Blakel Inc., but she can't sue under herself. She has to use the organization that she had the contract with. It might be a technicality they can look into. I don't know, but she's also not protected by Title VII because she's not an employee. She's a contractor under an entity. So she also doesn't get the federal civil rights employment protections either, which is likely why she didn't go to the federal government for a right to sue because she wasn't a protected party. When they signed this 17-point document, which was a contract, it was an additional contract for her to be a part of the film. This was not a contract that protected anyone but Blake Lively. The company that held the contract was Blakel Inc., and the services were for Blake Lively. The ends with us is it's a contract between. And interestingly, document. But it says reference is made to the certain actor agreement dated of May 5th, 2023 between It Ends With Us movie and Blakel Inc. for the acting and related services of Blake Lively in connection with the motion picture currently titled It Ends With Us. Whereas the parties wish to confirm the conditions under which lender has agreed to cause artists to render acting services on picture following the break in production related to the strike, the receipt of which is hereby acknowledged, company agrees to the following additional terms in connection with the artist's services and the use of artist's results and proceeds in the picture, which will be deemed incorporated into the agreement. So this was not a formal HR complaint. This was not a document that even noticed or took notice of HR complaints. There was no such evidence of any wrongdoing, nor was there any admission by Wayfair Studios because Wayfair didn't sign it. It Ends With Us movie LLC, which was signed by Jamie Heath. But a lot of these things are not protecting anyone but Blake. The document is referenced in her amended complaint, and here's how she describes it. Before returning to production following the guild strikes based on Wayfair's complete failure to investigate or address any of the complaints conveyed by Miss Lively and others, Miss Lively decided to speak up and require that Sony and Wayfair agree to a set of production protections to ensure a safe set for all of the cast and crew. Thus, in mid-November 2023, the parties agreed in writing to implement a list of protections enumerated in a contract entitled Protections for Return to Production, which included 17 provisions designed to require Wayfair to cease the on-set behavior of Mr. Baldoni and Mr. Heath. These provisions were designed to remedy the misconduct that Miss Lively and others had reported earlier that year. One of those provisions required an all-hands meeting to confirm and approve a plan for implementation that will be adhered to for the physical and emotional safety of Miss Lively, her employees, and all cast and crew moving forward. Another provision required that an experienced producer, Todd Black, be brought in to oversee production and ensure that the requested protections were adhered to for the safety and for all cast and crew. It says none of the requested protections were tied in any way to Miss Lively's creative input in the film and were made months before any discussions regarding the cut of the film. This is a lie. Justin says that his company, It Ends With Us movie, and Blakel Inc. entered into a document called Protections for Return to Production. He denies that Lively made any formal complaints, and he denies that Wayfair failed to investigate, and denies that the protections for return to production were designed to require Wayfair to cease any on-set behavior of Baldoni and Heath or remedy any alleged misconduct. He denies all the other remaining allegations. He also denied that this document didn't give her more control and creative rights. Lively came up with this document after they declined to bring her and allow her to see a rough cut of the film, and she was not allowed to see dailies for videos, something that she wanted access to see. So this document was after she had been told no. And interestingly, she says, while we reserve all legal rights at this stage, our client is willing to forgo a more formal HR process in favor of everyone returning to work and finishing the film as long as the set is safe moving forward. In order for our client to feel safe returning to the production, we are attaching a list of protections that will need to be guaranteed and observed by the film's producers. If the production is unwilling to accept or uphold these protections, our client is prepared to pursue her full legal rights and remedies. This is not intended to constitute a statement of facts and circumstances relating to the matter. It is not intended nor should be construed as a waiver, release, or relinquishment of any of our client's rights or remedies, legal or equitable. So she was willing to forego human resources. She never filed a human resources complaint. Blake's contract took control of the film in so many ways beyond what someone would do if they had a formal HR problem. Generally speaking, if you have an issue with sexual harassment on set, you do not demand control of the film. But this contract did. It enabled her to get full control over reviewing of playback and dailies, and only people that were approved by her and Todd Black could see or have reason to view any of the film that was related to simulated sex, nudity, or partial nudity. Only people that are deemed essential personnel, which has to be approved by her and Todd, could view the film. So for editing, how do you edit a film if you're not deemed an essential personnel? If she doesn't want to deal with Justin, all she has to do is say that he is not essential and therefore cannot see the video playback. Another aspect that gave her more control of the film: physical touching and or comments on the artist's physical appearance must only be done made in connection with the character and scene work, not as an artist personally, except as written into the screenplay or as strictly required in connection with makeup or costume preparation. There is to be no physical touching, including hugging, of her, on-set personnel, or her employees. There was no protection in any of these first four that have anything to do with anyone but her. It says there are to be no discussions with the artist of personal experiences with sex or nudity, including as it relates to conduct with spouses or others. Again, this only involves her. It says no one will enter, attempt to enter, interrupt, pressure, or request entrance into her trailer while she's in a state of undress for any reason. Again, only for her. There shall be no rehearsal or filming of artist, including artist's approved body double, of any nudity, partial nudity, or simulated sex, except as expressly permitted in accordance with the writer, and all footage previously shot without the writer may not be used. If you remember, no nudity scenes had been filmed, no kissing scenes had been filmed, and thus point 7 was moot. It says that she had have a representative on set with her at all times, which a lot of times she designated as her husband. This one is the kicker, though. Point 10. This is where she got them by, like she says, the balls. There shall be no retaliation of any kind against the artist for raising concerns about conduct described in this letter or for these requirements. Any changes in attitude, sarcasm, marginalization, or other negative behavior, either on set or otherwise, including during publicity and promotional work, as a result of these requests is retaliatory and unacceptable and will be met with immediate action. First of all, that is not even a legally binding number 10, because she's basically stating that any negativity, period, will be met with immediate action. Changes in attitude or other negative behavior as a result of these requests is retaliatory and unacceptable. Nothing in these requests state anything about sexual harassment. She didn't mention she was being sexually harassed. Basically, she could say to them, well, you said no about this. And then she could go up to, but point 4 is that I get to control what happens on the set when it comes to scene work. Or point 2 is I get to see the video playback and dailies, and you said no. I can sue you now. And if she said that this gave her no creative control, how does she explain scenes involving artists that involve kissing, depictions of sexual intercourse, or any other intimate sexual physical touching must be contained in the screenplay and the most up to date, drafted, approved by the artist in writing? Meaning, all filming of the romance in this film had to be approved by her in writing in the screenplay, meaning she was allowed to take over the screenplay and rewrite scenes if she wanted to. That is 100% creative control. Point 15 also gives her a ton of creative control. Any rehearsal or shooting involving artist or any other performer depicting the character of Lily, meaning that she had control over Isabella at this point, that involves nudity, including partial nudity or simulated sex, must be conducted strictly in accordance with the nudity rider and must be adhered to a final artist approved script. For the avoidance of doubt, there will be no use of footage in the picture that depicts any underage character or underage character engaged in intercourse or any form of penetration. So she would be able to control not only her script, but the script of Isabella. And because so much of this film has love scenes in it, it basically gives her a lot of creative control of the approved script. The reason why she was able to interfere with editing was because she had control over how those scenes were edited. She had control over what film was used, what cuts were used, how she looked, what direction it went for not only her, but also for Isabella. It could be kissing, just kissing, and she could control it. And so she was able to exert her control and say, you don't get to edit because if you say no, that's called negativity and I'll sue you and I'll use my legal rights to sue you. So, again, if you are someone that takes seriously claims of sexual harassment under the law, by the way, it's okay to bring to your employer or to an HR department that you are uncomfortable at work or you want to file a complaint for sexual harassment. But it's actually illegal to use claims of sexual harassment to threaten or gain control or to be weaponized against someone. And at no place in any of this document does it state that he did anything wrong or that anyone did anything wrong. All it does is have layers of people in there that she can use and get to and manipulate that is not Justin. She didn't want him to have control. She gets control of all the scenes for nudity or any love kissing, anything. If he has a change of tone or he's even sarcastic, she'll sue him. So think of it like this. You're trying to edit your film and she says, "Well, if you say no, I'm going to sue you, and then if you say no to this, I'm going to sue you." And I think that tone means you're retaliating against me. This document was used in a way that was abused because in any job, people get to be told no. There can be disagreements. If an owner of a studio says no, that doesn't mean they're retaliating. It means they said no. But she got them to sign a contract that made it so that anytime they said no, she could use that as a weapon. When I looked at this document, I was like, they never should have signed this. But she put them in a position where she said, if you don't sign this, I'll reserve my rights and I will sue you. And if you do sign it, I'll come back. But then if you change your mind at any point in time and you are not nice to me, I'll sue you still. So the threat was there whether they signed it or not. So if they didn't sign it, she could expose them and do all of this, right? Or if they didn't, if they did sign it and they didn't do exactly what she wanted, she could sue them and claim retaliation. And the only reason she's suing for this is because she's claiming retaliation. Because as the document noted, she waived rights to a formal HR investigation. So Justin Baldoni's answer to this case makes clear that her signing of this document and this 17-point bulletin didn't actually help anyone but her. Because how does her having control over sex scenes affect anyone but her? It doesn't. How does her getting a representative on set help anyone but her? It doesn't. How does no one being able to go to her trailer help anyone but her? It only helps her. Who does it help if you can't talk to her about anything personal? Her. Who does it help if you can't uh, have discussions about saying the word sexy? Her. Because at no place in the document does this reference any other characters, any other performers. No, nothing. The kissing, the depictions, that's all her. Only her. Only her. And this no physical touching was for her and her staff and her employees. None of the other actors or actresses. No discussions of personal experiences with sex or nudity with only her. No one will enter her trailer for only her. She can have someone on present for her. No one else can. She must be notified if she's exposed to COVID. No one else. This doesn't actually help anyone but her. And then she utilized the editing part of it that she had control over the sex scenes or the love scenes to completely take over the film. And the reason why she's not really suing for sexual harassment is because in that agreement, it states that only the retaliation would be her bringing claims. They all agreed that after they returned to work, nothing happened. So she can't go back and file a claim unless they retaliated against her, which is why she has to have this like retaliation clause in there. And that's why she's so hard, like going into that, because she can say, well, I can sue you for this, because she really can't sue for the sexual harassment because it didn't really happen. It isn't legally severe enough. She was an employee. She was hired as a contractor through her business. She's not actually herself, because she wasn't an employee of theirs, bound to the civil rights laws that she claims she is. And she knows this, which is why she never filed the federal right to sue, because she doesn't have a federal right to sue. She only could file in California, and there's no equivalent civil right protection in New York. So, really, what his answer exposes is that he is saying, I never had an agreement with Blake. I had an agreement with Blake Gull Inc. And then another clue to me of what their defense will be is that she waived her right to sue when they completed the project, when everything was done without a problem. And because she stated the project was completed without issue and everything was fine, they'll deem that as a waiver. And his final defense, listed at his defenses, his third defense is that she's barred because she waived her claims and she acted with unclean hands, meaning she used it as extortion, and she's stopped from asserting her claims because they'll say that she made a promissory estoppel, that she promised not to sue if they made good with this contract, and they did. That contract also is a fatal misstep for her because she effectively waives her rights when the project is complete. So, do you think this will hold up in court? Because recently, Brian Friedman said they answered the complaint because this complaint was so, there were a lot of errors in it and they didn't want to give them an opportunity to amend. And if they were going to do a motion to dismiss, they would get an opportunity to amend their complaint. But now she can't go back and correct any of this. And now they can use, she waived her rights. She promised that she wouldn't sue. She's not making good on that promise. And she's working with unclean hands. So, what are your thoughts? Did you expect this to be the outcome? Tell me in the comments below. Do you think this is the exposed fatal flaw to the lawsuit? Tell me. Make sure to give this video a thumbs up. Make sure to subscribe to my channel if you haven't subscribed and click the bell so you never miss a video. Thanks so much for watching. Bye, guys.